In a year defined by landmark decisions, impactful announcements, and new standards, clarity in the patent world comes as a welcome relief. It arrived via a Federal Circuit Court decision in August 2024 that settled certain facts related to obviousness-type double patenting, though BakerHostetler attorneys warn patentees to remain cautious. In BakerHostetler's second annual IP Perspectives Thought Leadership piece, the Intellectual Property Practice Group highlights myriad IP-related topics that are at the forefront of industry developments and current challenges and trends. I'm Leanne Lee, and you're listening to Baker Hosts. On today's episode, we discuss some clarity regarding obviousness-type double patenting. To provide us with insight into this topic, we have Ron Kern, a partner in the Intellectual Property Group at BakerHostetler and a member of the firm's IP Life Sciences and Advanced Materials team. Welcome to the show, Ron.
Thank you, Leanne. It's great to be here.
So to start us off, what is obviousness-type double patenting?
Obviousness-type double patenting, or ODP for short, is a judicially created doctrine that seeks to prevent patent owners from extending the 20-year exclusivity period of a patent. ODP occurs when the claims of a patent or pending application are not patentably distinct from the claims of another patent or pending application, when those patents and applications have common inventors or common ownership.
And under what circumstances does obviousness-type double patenting occur?
Obviousness-type double patenting can occur anytime the claims of a patent or pending application are close in scope to the claims of another patent or pending application. ODP, for example, often occurs between claims directed to a composition and claims directed to the use of the composition, such as claims directed to a drug and claims directed to methods of treating a disease with the drug. ODP can also occur between claims directed to an improved product or method and claims directed to the original product or method, such as between claims directed to the drug and claims directed to an improved formulation of the drug.
Now, why is obviousness-type double patenting such a concern?
During litigation, ODP can be used to invalidate one or more claims of a patent. During prosecution, ODP can be used to reject the patentability of one or more claims of the application. To overcome an ODP rejection, applicants or patentees can argue against the rejection, which can often be challenging, or can file a terminal disclaimer, which can reduce the term of the patent or application in question. A reduction in term can amount to a significant reduction in revenue from the patented product.
So, why was this particular case so important?
The Allergan decision addresses the effect of a child patent on a parent patent having patent term adjustment, or PTA. Although the term of a patent is 20 years from its earliest claimed non-provisional date, that term can be extended beyond the 20 years as a result of Patent and Trademark Office delays. This PTA could amount to days, weeks, months, or even in some situations, years. And that extra term is invaluable to patent owners, especially within the life sciences space, where revenue from a patented product may be greater towards the later part of the patent's life. For years, the patent community was concerned that a later patent or child could be used as an obviousness-type double patenting reference to invalidate or reduce the life of a parent patent. A shortened term of a parent patent could equate to a loss of significant revenue.
And does this case provide clarity to patentees?
Yes and no. Under the specific facts of the Allergan decision, this case provides some clarity. But like most things in patent law, it comes down to the facts. In Allergan, the court held that a later filed, later issued, earlier expiring child cannot be used as an ODP reference against its first filed, first issued, later expiring parent when they have a common priority date. In other words, a child with a shorter patent term cannot be used as an ODP rejection to invalidate a parent with a longer term. But even the Allergan decision creates uncertainty. The court, for example, used terms such as first filed and first issued, suggesting that the holding applies only to the very specific facts of that case.
Well, I have just one final question as we wrap up. What advice do you have for patentees going forward?
Although the Allergan decision provided clarity with respect to obviousness-type double patenting between a first filed, first issued parent and a child, it does not address obviousness-type double patenting beyond those facts. For prosecution, applicants should develop a claim and continuation strategy early to try to stay ahead of possible obviousness-type double patenting issues. For issued patents, obviousness-type double patenting is still a viable invalidation strategy.
Well, this has been a great conversation. Thank you, Ron.
Thank you.
If you have any questions for Ron, his contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with the lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.